The next matter to come before the court this morning is State of Ohio versus David Stoddard. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. If it does please the court, Attorney Anna Van Hall on behalf of the appellant, Mr. Stoddard, and I am fighting a bit of a cold, so nobody can hear me just scream or shout. I would like to reserve 4 minutes for rebuttal. That's all I could. Your Honor, if it pleases the court, I don't think anybody's going to argue this is a tragic case, and where you have one young lady who is dead, another young lady who was severely injured, and then a baby who passed away as the result of the mother's death. The problem that I had with the case, and I went straight to the two issues that I thought were the most substantive in the brief, and that is, first of all, is I don't think the state demonstrated clearly that there was purposeful intent to commit a homicide. I would concede two things. First of all, that if the young lady was shot and survived, if she had died, then obviously that would have been a clear-cut aggravated murder. It would have been a purposeful intent to commit a homicide, a gunshot straight to the head. The problem is that when you look at who actually died, and that being Mrs. Karam, the testimony is consistent in that what was happening is that Mr. Stoddard was shooting up in a dark stairwell. We know that there had been previous testimony as far as him firing weapons to scare people. I'm not saying that was good behavior that should be condoned, but we do know that there is a past history of using firearms in an attempt to scare people. We also do know that he's firing into a dark alley, or into a dark hallway with a person who ends up being shot, who he had a long-standing relationship with. If there had been threats, I know that the state had referenced threats that had been made and statements that had been made subsequent to this, subsequent to the shooting. But if this had been somebody who perhaps he had a long-standing beef with, or something of that nature, where we could demonstrate that there was some kind of animosity between the two people, I would openly concede that perhaps that would help satisfy the element of showing purposely. If, I know that there was an argument about transfer of intent in that regard to Mr. Mr. Nelson, if he had, I think the testimony was clear that if he had wanted to execute Mr. Nelson, he easily could have done so. But the fact of the matter is that what we have here is a chase, for lack of a better term, a firing up into a dark hallway, and unfortunately, a young lady was standing at the wrong place at the wrong time. And so when I'm looking at the purposeful element, I don't think the state is satisfied. I think what they've shown at most would be recklessness, and I think the evidence would demonstrate a felony murder, absent the element of purposeful, where the death was caused during the course of an aggravated burglary. And so what I'm asking the court with regards to the first charges is to send it back to the Court of Appeals, send it back to the Common Pleas Court, with the idea being that at most what we have here is a felony murder, 15 to life.
I have a question.
Yes, ma'am.
You said he started firing up the dark stairwell.
Correct.
Well, what were the surrounding circumstances? Why did he initiate gunfire at the stairwell?
The initial circumstances were is that he had already committed the one shooting of Mrs. and I'm drawing a complete blank on her name right now. Mrs. who?
Holman.
Holman. Okay. He had already shot Mrs. Holman at that point. He had had words with Mr. Nelson and was proceeding to, and I want to say, chase him into the stairwell. But I don't believe that there's any testimony such as that he was saying, I'm going to shoot you or I'm going to kill you or anything like that at the stairwell. I think that it was to try and scare the witnesses that would have been in the hallway itself. And so But there was nothing as far as an intent. I don't even know if the testimony is clear if he even knew Mrs. Karam was upstairs. I'm not sure the testimony was clear even if she was present in the house at the time. So, but that's what it perceived, that there had been an argument and so forth. And I believe that there was substantial testimony that alcohol and/or narcotics were in use amongst a number of the individuals in the house. Unless the court members have any other questions with regards to the first assignment error, I do want to move on to the second assignment. My concern with the second assignment error with regards to the merger issue is what we have here is a shock to Mrs. Karam that resulted in her death, and then her death was the cause of the baby's death. There was no, the medical examiner did testify that the baby had been shot separately, or that there was another intervening cause as to why the baby had died. In that vein, I think we have to look at a Johnson analysis, which is, but for the mother's death, the baby would not have subsequently died too. There was not, excuse me, a subsequent act to further the baby's death, other than the shooting of the mother. And so,
if the mother's pregnancy had been one farther and the baby was viable, so my understanding from what I read, isn't it true that the baby wasn't viable at that point in time?
correct. I believe the baby, and I want to say she was in her first trimester, I think, and so the baby would not have been viable even under, I think, advanced medical standards. So, but for, this isn't a kind of case where perhaps the mother could have been sustained through some kind of heroic life-saving treatment. I know I just read about a case where a mother, I think, had been kept on life support until the baby reached viability, which I think in that case was approximately 28 or 30 weeks along. In this case, there was no opportunity to try and sustain the baby's life. The mother was dead on arrival. And I don't know if they even knew she was pregnant. The paramedics didn't try and treat.
Had the mother not been shot and the baby carried full term, the baby would have been survived.
The baby could have potentially survived, yes.
Well, in any pregnancy, I understand that there are some risks.
Right.
But the likelihood that that child would be alive,
Right.
had the mother not been killed, is pretty high.
Correct.
So I don't quite understand your emphasis on the viability of the child. Are we allowed to kill unborn children just because they're early term?
No, I'm not arguing that. And I'm not trying to relitigate Roe versus Wade. What I am trying to do is say that but for the mother's death, the baby would not have died, based upon viability, based upon the nature of the shooting and so forth. It is possible you could have had a reverse scenario very easily, where the baby could have been shot through the mother's womb and the mother would have survived.
You're not making an argument that your client, because of the early term of the pregnancy, was not aware that there was a potential that she was pregnant?
No, I believe he actually knew.
He knew.
There was actually, I believe, testimony that he had assisted, with some of the pre-pregnancy type of things. I think he was excited for her that she was pregnant. So I'm not arguing in any way, shape, or form that he didn't know she was pregnant. First of all, I don't. Okay. Yeah. And so that's what I'm looking at, is that if you have one single act that leads to both the aggravated murder of the mother and then also the reckless homicide of the baby. And so I think that when you're looking at that, it's somewhat of an inconsistent verdict from that standpoint, because they're applying a reckless standard to the baby, but a purposeful standard to the mother. And so it does reflect a little bit back on the first assignment of error. But what I think what we're looking at is that when you have one solitary act that creates this, I think at that point we're looking at whether or not there is a Johnson issue and that there is a double jeopardy issue. So what I would ask the court to do is to send that at least that element of it also impacts the Judge Teodosio, so he can, I think the sentences would have to be merged, and there would have to be a Johnson analysis done. And I don't believe he did one. I think he was just looking at the facts the way they were.
So the record is not going to show anything in addition regarding a Johnson analysis done in the first instance as it relates to the merger of the mother-child charges?
I think Mr. Pierce may argue that, ultimately that wasn't what was done. The court did run them completely separate. It should have been merged for purposes of sentencing because it was out of one solitary act. So, unless the court has any other questions. Thank you, guys.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm the convictions and sentence imposed against Mr. Stoddard with regard to the aggravated murder of Anna Karen, her child, and the reckless homicide of her child, and the attempted murder of David Nelson. With regard to the evidence presented as to Mr. Stoddard's intent, the circumstances surrounding this show that he did shoot Jessica in the head, fired at David Nelson, followed Mr. Nelson on the stairs where he was with the two other ladies, the one lady who was killed and the other lady who testified, which was Miss Jocelyn Reason. And Mr. Nelson and Miss Riston both testified that Stoddard fired directly at David Nelson. So there is sufficient evidence in the record that Mr. Stoddard was acting purposely. He had already shot one person in the head. He was trying to shoot Mr. Nelson, followed him onto the staircase where Mr. Nelson was huddled with these two other ladies. He knew that Anna was pregnant, caused the death of the mother, which in turn caused the death of the child. This was all in close proximity. There may have been testimony that the stairs were not as well lit as they possibly could have been, but there was nothing to dispute that Mr. Stoddard knew that there were people on the stairs. He went to the stairs specifically to shoot at Mr. Nelson. Mr. Nelson testified that he would have been shot if the gun had not jammed. So with regard to the first assignment of error, the state would argue that there's sufficient evidence and the weight of the evidence supports the convictions for Mr. Stoddard. With regard to the second assignment of error regarding consecutive sentences, this court has held that when there are multiple victims in an offense that would be conduct towards another person, that in those cases it's proper to have a finding that the offenses are not allied, that there is separate animus for each person. And I do not believe that there's any case law that would support a finding that when a mother dies and her unborn child subsequently passes because of that death, that is any cause for there to be a finding that the matter should merge. Those are two separate deaths. They are under the statute. If you cause the death of a person or their unborn child, that is enough for the homicide.
Would you say that would be true if the shooter was unaware of the pregnancy?
I would, because the statute talks about causing the death of that person or their unborn child. So maybe it would, I don't think the charge, would have affected probably the charge, but I don't think it would affect the sentence. If they are found guilty of the charge, which would suppose that they acted purposely, recklessly, etc., then I think the sentence is fair because the jury has already found that they're guilty of that charge, that they had the mens rea to commit whatever the underlying offense was. So here the jury had found that he had committed the death of Anna as well as the death of the child. So those two things, based on this record, I believe is sufficient to say that they should not merge, that they're separate offenses, they're separate victims, and that would be a separate animus for each one. And I think it is a really slippery slope to go down if the court is going to make a decision as to at what point would an unborn child's death merge with the mother's.
I'm not sure. The argument is, I'm not sure, but I'm not sure that the argument is that it's by virtue of the fact that we're talking about a fetus here, the mother is not viable. But what if the child had been born and was standing behind the mother? He attempted to shoot Mr. Nelson. He fired one shot, and it hit both the mother and child, killing both of them. Then do we have a merger problem?
I would argue that the offenses still do not merge, because when there are multiple victims, each victim would have their own sentence. That would be the state's position. No,
Okay, sorry.
I mean, it calls to my mind a question of, like a terrorist attack. If you're saying, well, they only meant to harm one person, but there's 20 or 30 people harmed, it wouldn't be logical to me that there's one explosive that it harms multiple people, that they would only serve one sentence. That, carried out to the extreme does not seem logical to me. It seems to me if you harm multiple people, you have convictions for each person, that you should be sentenced, that they should not be merged, that they are separate with separate animus. And that would be the state's position.
And then this was charged as it relates to the fetus in terms of a reckless standard?
It was. Thank you, Your Honors.
I would have a slight disagreement with DiMartino with regards to trying to compare this to a terrorist attack. In this act, what we had is a single bullet that caused the deaths of individuals.
So you would distinguish a bullet as opposed to a bomb thrown into a group of people?
Yes, because when you look at what the purpose of a single bullet is, it is a general rule intended for one bullet, one target. If you look at what a bomb is designed to do, a bomb is designed to inflict mass casualties or multiple injuries. Bombs are going to look at. So I think you do have to somewhat, to a certain extent, look at the cause and the instrument of the harm. And so in this case, what you do is and also how it relates to the act committed. So for example, in a bomb type of situation, and without going into pyrotechnics too much, what you do is you have shrapnel that is expanded in a number of very different directions. And that's where a bomb can get the ability to kill multiple people.
So shotgun?
A shotgun, like, depending on the type of
We're
shotgun.
going down a
the
slippery
bullet.
slope here, aren't we?
Yeah, I mean, I'm not trying to go down a slippery slope, but I'm actually trying to keep us from going on a slope, because my concern is that what we have is we have a single act by the individual that results in the death of the mother, but for the death of the mother, you don't have the death of the fetus. And so that's where I'm looking at it as, is that it's one bullet, one target, one act, but for the death of the mother, you do not have the death of the fetus. And so that's where I'm saying that maybe the analogy to a terrorist attack is not viable. Luckily in Ohio we haven't had terrorist attacks, and so we haven't had to deal with that issue in our court system yet. But I think that when you're looking at it from the Johnson analysis and the double jeopardy issue, I think you do have to look at the fact that but for the one shooting, you would not have had the other death.
Forgive me, I sometimes get my cases confused.
Correct.
Was your client aware that the victim was pregnant?
Yes. Yes, and I believe if I remember, and I'm sure the court will correct me if I'm wrong, I don't believe that she was shot in the belly or the area of the body that would have been. Yeah, it was a head shot, so it would not have been in an area that would have been in the area of the baby. If you had shot into the area of the belly, obviously I think you might have a little bit of a different argument, but it was a head shot, so.
Well, clearly one can understand that you kill the mother, the fetus is likely to be dead.
I agree with that. Unless the court has any other questions. Thank you, ma'am.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will mail to both sides as well as posted on our website and the Alaska Supreme Court website. Thank you.